In 1927, the Supreme Court ruled that America could sterilize its own citizens. Over the next 50 years, more than 6,000 people were sterilized by the state. Some were told it was an appendectomy. Some were never told at all. And when it was done, the room didn't change. The next number was called.
Between 1907 and 1979, more than 60,000 Americans were sterilized by state authority.
The first law was passed in Indiana. Within 2 decades, 32 states followed. The language was never violent. It was clinical, preventive, administrative. The word used most often was not punishment. It was protection, protection of the public, protection of future generations, protection of the state's resources. In California, the program ran for decades and accounted for roughly a third of all sterilizations nationwide. In Virginia, the laws remained on the books until 1979. In North Carolina, the program targeted welfare recipients as late as the 1960s. These were not rogue operations. They were funded, reviewed, reported in annual summaries. They had budgets. They had oversight committees. They had filing cabinets. 32 states passed sterilization laws. Most called it public health.
The system did not need to target everyone. It needed people who had less power to refuse.
In the early years, the targets were residents of state institutions, people labeled feeble-minded, people labeled epileptic, people labeled unfit. These labels were not medical diagnoses. They were administrative categories. A social worker could write feeble-minded on an intake form based on a short interview. A superintendent could confirm it. A board could approve it in a single afternoon. In later decades, the categories shifted. In North Carolina, the Eugenics Board reviewed cases referred by county welfare departments. Many of those referred were Black women. Many were young. Many were poor. A 14-year-old girl in Winton, North Carolina, was sterilized after being labeled feeble-minded by a caseworker who spent less than an hour with her. She was told she was having an appendectomy. She learned the truth years later. The categories changed over time. The mechanism did not. The categories changed. The mechanism did not.
It begins the way many government processes begin. A form, a practice tone, questions that are not meant to understand.
They are asked to fit a person into a decision tree. Name, age, address, number of children, source of income, a line for mental capacity, a line for recommendation. In many states, the intake form itself contained the outcome. The questions were structured so that the answers pointed in one direction. A caseworker in Mecklenburg County once processed 11 referrals in a single week. Each file followed the same format. Each recommendation read the same way. The intake produced a summary that looked authoritative because it was written in the language of institutions, because it carried a case number, and a case number moves through a system the way water moves through a pipe. It does not ask where it is going. A person becomes a case number. A case number becomes a route.
In 1927, the Supreme Court ruled 8-1 that the state could sterilize Carrie Buck.
Justice Oliver Wendell Holmes Jr. wrote the opinion. He called it a matter of public welfare. He wrote, "3 generations of imbeciles are enough." The decision was not hidden. It was celebrated. It became the legal foundation for sterilization programs across the country. After Buck v. Bell, states did not need to justify their programs case by case. They had precedent. A case is routed. A report is read. A recommendation becomes a motion. A motion becomes a signature. The signature becomes authority. And authority becomes permission for everyone downstream. In a system like this, approval is a kind of shelter. If harm occurs, the person executing can point upward. If questions arise, the office can point sideways. If blame appears, it can be distributed across a conference table until no single person holds enough to be accountable. No one needed to feel responsible. They needed to sign.
After authorization, the system switches into logistics. An appointment is made.
A bed is reserved, a guardian is notified or bypassed. A consent form is produced in the correct format. In many cases, the patient was told the procedure was something else: an appendectomy, a routine operation, a necessary correction. In some facilities, women were sterilized during childbirth without being informed. The procedure was added to the chart after delivery, a note in the file, an extra line on the surgical report. If a signature was missing, a substitute mechanism was invoked. A judge, a superintendent, a welfare board, someone who could legally stand in for the person whose body was being decided upon. This is how procedure protects itself. It creates alternative routes around refusal, not by force in the hallway, by options on paper. The act was hidden inside scheduling. It became just another appointment.
California sterilized over 20,000 people. The program ran for decades.
There is a moment when a policy becomes a habit. After that, continuation is easier than review. The annual reports listed the operations alongside other institutional statistics: bed counts, discharges, deaths, sterilizations. In North Carolina, the Eugenics Board met regularly. Cases were reviewed in batches. Some meetings lasted less than an hour. Dozens of lives were decided in a single session. A clerk learned which folder needed which stamp. A supervisor learned which cases to forward without questions. A committee learned how to clear the agenda before lunch. The process became faster, cleaner, more confident, and the people inside the system stopped seeing the decisions as exceptional. They saw them as work. Once it was routine, it persisted for decades. Numbers replaced questions.
Elaine Riddick was sterilized at 14. She was never told.
In the file, the procedure is complete. A date, a signature, a final stamp. The case is closed. But what is closed in the file is not closed in the life. She had been raped and became pregnant. The state classified her as feeble-minded and promiscuous. Her grandmother, who could not read, signed the consent form with an X. Elaine did not learn what had been done to her until years later, when she tried to have more children and could not. She was not alone. Across the country, thousands of women discovered the truth only when their bodies refused to do what they expected, when doctors explained what had been removed, when records were requested and the line items became clear. The system was built to close cases. It was not built to face what it had taken. The file was closed. The life was not.
These programs did not end because the paperwork became uncomfortable. They ended when the cost changed.
In 1973, it was revealed that two young black sisters in Montgomery, Alabama, Minnie Lee and Mary Alice Relf, aged 12 and 14, had been sterilized by a federally funded clinic without informed consent. Their mother, who could not read, had signed a form she did not understand. The case made national news. Lawsuits followed. Investigations followed. Federal guidelines were rewritten, but the programs did not vanish overnight. North Carolina's Eugenics Board continued reviewing cases until 1977. Virginia's law remained on the books until 1979. California's prison system was found to have sterilized nearly 150 female inmates between 2006 and 2010 without required state approvals. In 2013, not 1953, visibility forced a different kind of record, one that included what the file had omitted, one that included what the form had treated as routine. It ended when the silence became more expensive than the program. Visibility changes the cost.
It is tempting to treat this as a story about cruel people. It is more useful to see it as a story about systems.
A system that can label, a system that can route, a system that can authorize, schedule, and record completion. Once those pieces exist, continuation becomes natural. Not because it is right, because it is the default output of the machine. No single clerk decided to sterilize 60,000 people. No single judge intended a 40-year program. No single social worker planned for a teenager in Winton to lose what she did not know she was losing. But each one carried a piece, a form, a referral, a stamp, a signature. And when default outputs cause harm, the harm looks like work, like policy, like service, like something that was already approved. It did not require a villain. It required a system.
When the state calls it procedure, who is authorized to refuse?
North Carolina issued formal apologies in 2002. Virginia followed in 2002 and again in 2015. California apologized in 2003. Compensation programs were created, in some states, decades after the last operation. Some survivors received payments. Many had already died. An apology is a document. A compensation check is a document. Neither undoes what was done in a room where the paperwork was already complete. When the state calls it procedure, who is authorized to refuse?
Still here? Subscribe, hit the bell. Next one's waiting.